All right, please, just a very brief response.
Sure, we're getting ready to go to your next motion.
I understand. Just the reason I would say that the questioning is essentially an interrogation, accusatory, because it's asking about wounds of someone who the police suspect may have stolen an automobile, which also, so there's an implication there that the wounds may be related to her theft of a vehicle, or that she may have been in a fight with the alleged victim in the case prior to that. So they've already established this belief that she has engaged in grand theft auto. When they confront her, she has wounds on her face, and they're asking her about that. So the implication is that somehow the wounds that that they're seeing would be related to this supposed criminal activity.
All right, so let's go to your third motion.
Mr. Judge, thank you. Of course, motion suppression, amended suppression motion number 3. Addresses the affidavit, and the court should have the affidavit for arrest warrant signed by Judge Foster.
Well, this goes to the issue we were talking about a moment ago.
Correct. So if I could give the court case.
So an unmirandized statement cannot form the basis for the probable cause affidavit for an arrest warrant.
Well,
If the person was already in custody.
the argument is that, again, this is for argument's sake, you haven't ruled on it, but for argument's sake, if the court were to determine that these statements were illegally obtained, okay, that's really the issue here. So there's an assumption. Again, we have this cascading effect. So if the court rules against us in motion 2, then that sort of alleviates any analysis with regard to motion 3. But in the Neary case, state of Florida, case from 1980, citation 38477 881. It really lays out, what the court's obligation would be. And again, it's another analysis that you would have to conduct. In Florida, and I'm on page 4 of 7, Your Honor, last full paragraph. In Florida, the law is clear that a search warrant, and I'll argue in this case also an arrest warrant.
Sorry, where are you? Page 7?
Page 4. 7.
Okay.
Last full paragraph, starting on the second sentence. The law is clear that a search warrant is not invalidated by inclusion of illegally obtained evidence in the supporting affidavit, where the affidavit contains other valid allegations sufficient to establish probable cause. Thus, the critical question is whether the independent and lawful or the lawfully obtained information in the affidavit suffices to establish probable cause. And again, it's building on the argument that we made with regard to the motion to suppress motion 2. If the court determines that those statements are illegally obtained, then the court essentially has to excise that from the affidavit that was submitted by Detective Wayne Harrington to Judge Foster on May 17, 2018, removing the statements that Ms. Seibert made, because he included in that affidavit that, quote, Seibert denied ever being given permission to drive Cummings' vehicle and denied ever being in Cummings' vehicle. You take that statement out, Judge, our argument is that there is no probable cause contained in this affidavit. I couldn't find a single case that suggested someone merely being seen driving someone else's car would give rise to probable cause of the crime of grand theft auto. And that's all that the police would have had without her statements, is that she had been seen on video driving Joey Cummings' vehicle the evening that she went to the gate station. So that's our argument with regard to motion number 3.
Ms. Person.
Having just been handed the case law that defense was referring to, Miri, I haven't made it all the way through. However, what is apparent from Miri to begin with is they're dealing with illegally seized physical evidence.
And, well, I mean, yeah, the case, the pertain, the case that you just provided to me, I understand that, look, I mean, even if you get a statement that in violation of Miranda, you don't suppress physical evidence which is gained as a result of the un-Miranda statement. You just suppress the statement itself. I think their argument is that the affidavit for PC in this case has a statement attributed to Ms. Kessler that she had never ridden in the car, didn't have permission to drive the car or whatever, and never had contact. So you tag, and that statement is critical for probable cause. That's the way I read their argument. Okay, I don't see number 3 as trying to suppress any physical evidence. I think you get later they're trying to do that, which I think you're gonna have to contend with that case law, but I don't see that on number 3.
Okay, and I'm sorry if I wasn't clear. I'm distinguishing Miri from the case at hand because Miri was dealing with illegally seized evidence then being used to go forward. We're not dealing in this case with illegally seized evidence. We're dealing with the question of whether there was a Miranda violation or not. And the Patain case that courts referred to and I've provided to the court and defense counsel, which is 124 Supreme Court 2620, the United States Supreme Court v. Patain with Patane, decided in 2004. It is specifically on point in that just because Miranda is violated, if it's a voluntary statement, it can still be used to support the probable cause. So based on Patain, the state's position is that it can be used for probable cause and does not need to be excised.
Okay.
Okay, we have.
Go ahead.
In addition to the state's position based on the United States Supreme Court case of Patain, that even if the statements were in violation of Miranda, that it can still be used to support the arrest warrant for grand theft auto. I would want to make a side note. Defense counsel is arguing the second statement by the defendant was the interrogation, and that is where'd you get the scratch on your face? That still leaves us with her first statement, which is, I don't know anything about Jolene Cummings or her car. And then of course she has already said that in a phone call on Tuesday morning at 7:45 to Detective Harrington, that she doesn't know anything about Jolene Cummings or her whereabouts. So I would also argue that it's kind of a fallback or a secondary, that defense counsel just makes this blanket statement that take those statements out, which I don't think is required. But if you did take those two statements out, that there's insufficient probable cause for grand theft auto, because he's never heard of a case that just being seen driving a vehicle constitutes grand theft. I would refer the court and defense counsel to the jury instruction for theft, which is the state has to prove 2 elements beyond a reasonable doubt: that the defendant knowingly and unlawfully obtained or used or endeavored to try to use the victim's vehicle, and that she did so with the intent to either temporarily or permanently deprive the victim of her right to the property. There's nothing in there about consent. Consent is actually an affirmative defense and is not required for us to put that in the probable cause. But she's not just seen borrowing Jolene Cummings' vehicle to go through a drive-through during normal business hours. She is seen at 1:17 in the morning, parking Jolene Cummings' vehicle in a closed business's parking lot, the Home Depot, while dressed in black, and then walking over to the open gate station and then calling a taxi to leave from there. So not exactly like borrowing a car. So the state's position is, should the court disagree with us as far as the holding in Pantane, that there in excises a statement, there is still probable cause to support the grand theft arrest warrant charge.
Vote on that, council.
When the state referred to other statements that Ms. Kessler had made, such as doesn't know anything about Jolene Cummings or her part, those statements were not contained in the affidavit for the warrant. So,
I mean, it says Seaver denied ever being given permission to drive Cummings' vehicle, denied ever being in Cummings' vehicle, which I do recall the testimony was that was there was a denial on a Tuesday morning phone call. But would you, if the statement remains, okay, would the defense concede that there is probable cause in the affidavit to sign the warrant? I'm just trying to flesh out where, what I need to concern myself with.
I think so, Judge. I think if the statement, yes, if the statement survives the analysis in the second motion, yes, then the probable cause, the affidavit would no probable cause.
Okay. Let's talk about your next motion.
Motion number 4. And just to remind the court, there was a joint stipulation number 3, with regard to the facts that are alleged in amended suppression motion number 4.
Right.
And that stipulation reads, after an arrest warrant was signed by the Honorable Robert M. Foster on May 17, 2018 for grand theft auto, the defendant was transported to the St. Johns County Jail on May 17, 2018 at approximately 2:25 a.m. by St. John's Deputy Vanessa Gillis. Defendant remained at the St. Johns County Jail until she was picked up by the Nassau County Sheriff's Office Detective Beasley on May 18, 2018 at 8:32 p.m. Defendant was booked into the Nassau County Jail on May 19, 2018 at 12:30 a.m. And also, just for record purposes, on cross-examination, Detective Harrington testified that obviously they had made contact with Ms. Kessler just before midnight on May 16th, and that he had the warrant was signed by Judge Robert M. Foster approximately between 1 o'clock and 1:15 a.m. So that is the timeline from the time she stopped, the time the warrant is signed. And of course, the warrant, as the court has for arrest, indicates that she was to be brought in stanter, which of course means, and of course, court can certainly Google the definition of stanter, but it means immediately, instantly, now. And so we were not able to find a tremendous amount of case law on this issue. It may in fact be a case of first impression here in Florida, but we argue that this delay from May 17th at approximately 1:15 a.m. until she is picked up the next day, May 18th at 8:32 p.m. Was clearly an unnecessary delay. That again, looking forward to the motions that you're about to hear. This delay then leads to this sheriff's office seeking other warrants. Well, they're from the St. Johns County judges while she's being held in the St. Johns County Jail.
Okay, well, let's break this down a little bit, okay, because you've done first appearance for a long time, okay? You know that when someone's arrested in this county, whether it's on a warrant out of Duval, Collier, militia, whatever, they gotta go in front of me first appearance. Okay, you don't just say, oh, well, you're there on warrant out of, this county, so we'll just, you're just gonna stay here, we'll call them up. You know, they gotta go through first appearance, you go through the normal procedures that anybody who's arrested in the county goes through. You agree?
Correct, yes, sir.
Okay, and so you're saying that there was a problem constitutionally with the fact that Nassau County Sheriff's Office could not arrest her in St. Johns County. They had to have St. Johns County deputies arrest her. And then St. Johns County does their thing. And then they bring her back later, I guess 14, 16 hours back up to Nassau County. And there's something constitutionally wrong with that. I'm having a hard time accepting.
The argument, of course, Your Honor, even if she had to go in front of the judge in St. Johns County that morning,
Right.
there were 9 Nassau, well, I take that back, 7 Nassau County Sheriff's officers there in St. Johns County when she was arrested. It should have been very easy for them to collect her very quickly and bring her back to Nassau County.
But you would, by statute and rule, she would have had to have been brought within 48 hours in front of a magistrate in St. Johns County.
Yes, sir.
Right?
Correct.
So you couldn't, those 8, whatever Nassau deputies couldn't do anything with her until she went through whenever their first appearances was, whether that was in the morning or in the afternoon or whatever, which I don't have any evidence of that, but I'm pretty certain that they would have had to go through whatever process is down there before they could be brought up here. Correct?
Judge, again, I don't have any case law on it. Was it really this is a sort of a novel issue? I will certainly admit, and again, maybe an issue of first impression, but that's sort of our argument is what's contained in the motion.
Okay, well, I know, but it goes on to other matters, so that's why I'm really trying to just kind of talk with you about it.
Yes.
You can see where you're coming from. I've never encountered it. I'm not even sure what, you're trying to suppress photos, bodily materials, I guess they were the vehicle swab or something like that while they were down there.
Well, our argument is that she's essentially being unlawfully detained there in St. Johns County, and she should have been brought back here to Nassau. So during that unlawful detention, the sheriff's office is then obtaining additional warrants to collect additional evidence while she's being unlawfully detained there, because they did not comply with the order of Judge Foster in the arrest warrant.
Okay, well, I think most warrants say, they have a boilerplate language of, instant or for all defendants, they don't immediately come back. They never immediately come back. It takes time to go through the process. And I'm just not sure that, I'm still trying to understand what the problem is from an evidentiary standpoint. I'm saying that they held her, she was held illegally for 14 hours or 13 hours. And so therefore, anything after that, any evidence that was taken after that is fruit of the poisonous tree.
Was unlawfully obtained. She's being held illegally there. Any evidence that's obtained while she's being held there illegally, correct, should be suppressed.
And what evidence was taken down there? Or booking photo?
I believe that's one of the other motions.
Okay, then we'll flow, we'll address it as we come along, all right? Ms. McPherson?
I did one step better than Google. I looked in Black's dictionary, and Black's Law Dictionary defines instanter as immediately, instantly, forthwith, without delay, gives a couple examples, and it says the term was usually understood to mean within 24 hours. Which of course describes the situation as the court has described as that every time a defendant is arrested out of county with a warrant that's directed to all law enforcement, to all the sheriffs or deputy sheriffs in the state of Florida, that Nassau County Sheriff's Office cannot arrest in St. Johns County. So St. Johns County had to take her. And then within the warrant itself, it directs that you are hereby commanded to arrest the defendant if she be found in your county and safely keep her, so that you can have her body before a judge of the Nassau County Circuit Court at the courthouse in Yulee and stand her to be dealt with according to the law. So St. Johns County arrested her because she was in their county, and then she was subject to a search. But that was a search that was done on the 17th pursuant to a search warrant. So she wasn't held any unreasonable period of time. There's not one shred of evidence that she was held in Nassau County for an unreasonable period of time before she was released to Nassau County. And then defense counsel then takes this argument that the search warrant is somehow invalid, acknowledging that the Nassau County Sheriff's Office doesn't have the authority to arrest her in St. Johns County, and then says that that's an unlawful detention. Well, there's nothing unlawful about her detention. The detention was pursuant to an arrest warrant. They're taking issue then with the location of her detention. And how does the location of her detention then result in the suppression of evidence that was obtained per search warrant within just hours after she was arrested in St. Johns County? There's no case law for that, because that's not what the law holds. Her body was in St. Johns County because she was arrested in St. Johns County, and so the search warrant was obtained in St. Johns County to obtain her bodily samples as soon as possible after her arrest. The delay did not lead to any type of unlawful detention, nor did the delay lead to anything wrong with the search warrant being executed in St. Johns County, where the body was, as opposed to Nassau County. No, sir.
All right, let's go to your next motion and build off of the arguments that you made.
I don't believe I have any additional argument to make with regard to suppression, amended suppression motion number 5. I would just remind the court, this is the motion, joint stipulation number 1 would apply to this motion. States just stipulated to the items that were in fact collected by Detective Corporal Samantha English of the St. Johns County Sheriff's Office. But again, we're relying upon the arguments that have previously been made with regard to the use of un-Miranda statements by the defendant in seeking the warrant, and her being held in St. Johns County for a defending woman.
All right, well, but you do still have to, I mean, there's a lot of overlapping issues. I mean, you would agree that these are, you know, the photos and all these other items that were taken is physical evidence, correct?
Correct. Yes.
So you have to contend with the Patain case and the law that says, you know, even if you get an un-Mirandized statement, you don't suppress physical evidence that is obtained as a result of the statement. So doesn't that apply to, you know, some of this physical evidence that you're talking about trying to suppress? I mean, assuming for the sake of argument you're correct, it's an unlawful detention and whatnot, we're still talking about.
I think that's why it's distinguishable. There certainly is this joint. It's not simply the statements alone. I mean, you have the statements that we contend were illegally obtained and then used for the affidavits warrant. But then you also have that coupled with an unlawful detention and unnecessarily long detention in St. Johns County where she shouldn't have brought that here. So I think I would argue that is what would distinguish it and why in this case, the court should grant our motion.
Okay. Is there any other motions that you want to specifically argue, or is everything covered by the arguments that you laid out here? It's just
Right. I would
applying the different items of evidence.
correct. That would be the case also to amended suppression motion number 6. There would be no additional argument there. There would also be amended suppression motion number 7, same argument. Your Honor, with regard 8, 9, and 10 are separate. And if we could, motions 8 and 9 would be argued by Mr. Miller. Sure.
Well, before we go to 8 and 9, I understand that they say they don't have any additional argument, but I have some.
Okay.
In defense counsel's, what I just understood defense counsel to say is they're resting on the arguments that they've made to the court this morning, that she was illegally detained because she went to St. Johns County on the warrant before she was brought to Nassau County, and that the statements, ignoring Pantane, the statements should not have been in the probable cause statement for her arrest, and therefore, I'm not sure what they were saying after that, but they do allege other things in the suppression motion number 5. In the suppression motion number 5, in paragraph number 6, they acknowledge that there was an affidavit for a search warrant for her bodily materials. And they said that the affidavit in support of the arrest warrant makes no allegations that connect the defendant with any crime relating to the fact that a woman is missing. They also allege that in paragraph number 7, that the item sought, they say arrest warrant, but it would be search warrant, including DNA, fingernail scrapings, gunshot residue kits, swabs of injuries, and other bodily materials, far exceed the scope of materials that could be accessed in relation to a grand theft auto. There are no allegations in the affidavit for the search warrant which support any need to seize these bodily samples from the defendant. And then in paragraph number 8, they claim that the warrant was overly broad and not based on any allegation of criminal activity of the defendant relating to the missing woman. So to those that are argued in the motion, but not argued by defense counsel, the state would point out to the court that in the search warrant from St. Johns County, that the judge who signed the search warrant found that there was probable cause to believe that a grand theft auto in violation of 812.014 Florida statutes, or a murder in violation of section 782.04 Florida statutes had been committed, and that the evidence relevant to proving said felony is being kept in or on the person located within the 7th Judicial Circuit. So they were articulated and probable cause found by the judge who signed the search warrant on the 17th of May, 2018 in St. Johns County. I believe, yes, that was Judge Alexander. The allegation set forth in the search warrant affidavit was that Ms. Cummings was missing. She was last seen on May 12th, 2018 at the Tangles Salon. The defendant admitted that she last saw Ms. Cummings at 5 p.m. on the 12th, leaving Tingles, and that a few hours later, being 5/13 of 2018 at 1:17 in the morning, the defendant is on video parking the victim's motor vehicle at the Home Depot parking lot and taking a taxi back to Tingles. That the testimony today is that there were, the warrant, and taking a taxi back there. And then it goes on to say that she had the obvious injuries to her face and that the Tingles hair salon had been processed by the crime scene technicians, and a small amount of blood was located inside the hair salon. So the state's position then is that the search warrant 1 is valid on its face and that the probable cause was established. It is not overbroad. And so the search was lawful and appropriate. And then our second argument would be that if there was some fault with the search warrant, then the serving officers had obtained the search warrant in good faith. It was approved by the issuing judge, and there's been nothing alleged that there's any material and intentional false representations within the warrant. So that's as to number 5. As to number 6, in number 6, the defense, in addition to the bootstrapping to the previous motions, as defense counsel said, they're relying on, they also allege that the search warrant issued by St. Johns County of her vehicle makes no allegation that she was a suspect in criminal activity regarding the missing victim. That is incorrect. The search warrant sets forth the probable cause for grand theft auto and murder. And then in number 8, 9, and 10 of their motion number 6, they represent to the court that there was no affidavit to support the second warrant issued by Nassau County. And because there's no affidavit, there's no probable cause, and that the search warrant was overbroad. So is defense counsel abandoning that argument?
I thank the state for bringing that back to my attention. We have never been provided, Your Honor, with an affidavit in support of the Nassau County, the second Nassau County warrant search. Her vehicle. So sort of puts us.
Providing defense counsel and the court with the emails where defense counsel was provided with the affidavit in 2019. And when they said they didn't have it earlier this year, it was again provided to them. So there is an affidavit and it has been provided. This is the first time.
We've got the first step. We've never received the second affidavit. So according, state was actually providing you with a copy of it now. That would be wonderful.
I will resend the email that's been sent that has the correct affidavit attached to it.
It seems like she's, I mean, you're talking about the May 18th search warrant, counsel, is that correct? Mr. Townsend? Talking about the affidavit for the May 18th search warrant.
Correct, yes, sir.
And it seems like that's what they've been sending to you the last couple of years.
Yes, sir, Judge. We were not receiving that. Just need a chance to review it.
This is one motion. Well, that motion's made and closed.
We agree that that motion will be moved.
Some of the entire,
Yes, sir.
entire six,
With regard to, yes, sir.
the entire motion is suppressed,
Well,
number 6. Unless there's I find that there was an illegal detention.
correct. Again, going back to the. Everybody's got statements and said, right.
Everybody's got the affidavits, everybody's got the.
So just with that regard to that argument.
All right.
Okay, and just so it may already be clear to the court, there, in the search or regarding the search of the defendant's Kia, there were actually 4 search warrants. On 5/17 of 2018, St. Johns County got a search warrant with the probable cause set forth, believing a grand theft, auto, or murder was committed, and they just seized the Kia from the rest area and towed it to their forensic unit. The next day, on May 18th, 2018, Detective Harrington got the search warrant from St. Johns County alleging probable cause for a grand theft auto or a murder to seize the Kia and bring it back to Nassau County. And then on May 18th, 2018, Detective Wayne Harrington got the search warrant in Nassau County once the car had been returned to Nassau County, setting forth the probable cause for grand theft auto or murder to search the Kia for DNA, Ms. Cummings, Ford keys, the electronic devices, including the cell phone with mapping or internets, and that was signed by Judge Falgren. And then there was actually one more on May 24th, just to remove the pedals for blood evidence. So with that, then the state's position is that this search warrant was a lawfully issued search warrant. I understood correctly, defense is still trying to make an argument that if there was an illegal detention of Ms. Kessler because she wasn't brought back from St. Johns County to Nassau County quick enough, I do not see, one, I disagree with that, but 2, I don't see how that gets you to then a lawfully issued search warrant would not remain valid because it was lawfully issued and executed in Nassau County, not to search her, but to search her vehicle. And then further, that the officers then relied in good faith on the search warrant that was issued in order to execute the search warrant. And there's been no allegation that there's anything as far as any intentional material misleading facts within that search warrant. So that's number 6. And then defense counsel as to suppression motion number 7 to suppress the evidence obtained as a result of a search warrant issued for the contents of the defendant's black flip type cell phone. They did list all their other motions as a reason for it. But then they also They also alleged that number 12, that, and again, if I can step back for just 1 second, there were 2 search warrants issued for the black flip type cell phone. The first one executed by Nassau County Sheriff's Office, and then the second one executed by FDLE because they had the better software. So in number 12, paragraph 12 of defense counsel's motion number 7, they allege that the affidavit for the search warrant to search defendant's LG cell phone was made conclusory allegations and fails to state alleged facts sufficient to establish probable cause, and failed to enunciate precisely what felony had been committed. The probable cause was found for grand theft the probable cause was found for grand theft or murder. They also say in number 15 that FDLE executed the warrant without authority from the court. That is incorrect. And of course, there's been no evidence of that. So that's our position on number 7.
That's number
And we have that's number 8. Yeah.
8. Mr. Townsend, you are free to take the floor.
Mr. Miller.
Mr. Miller is free to take.
States agreed to submission of the affidavit for search warrant. It's dealing with the storage unit at Sadler and the search warrant.
One copy of that,
I'm going to provide that for the record.
that's your stipulations.
Okay. It's not part of the stipulations. Number 8, the argument deals with Detective Brewer going to the storage unit facility at 2137 Sadler Road. And that the applicant, Detective Kelly, that's Kelley, sets out on May 18, 2018, Detective Brewer located a storage unit rented to Jennifer Seibert, located at 2137 Sadler Road, Fernandina Beach. Employees verified Seibert's the renter of Unit 17. The unit is in her name only and been rented since January 13, 2018. And it refers to the gate code and times that she's visited there. And Detective Harrington had noted that Detective Brewer obtained a printout of the dates and times to use her access number to enter the gated storage facility. So basically, it's the business records obtained there for submitting that that piece of evidence, particularly the log of her comings and goings, was obtained improperly without a warrant. Under this right to privacy, we'd also cite to the right to privacy in Florida being broader in scope than under the federal constitution, under Florida Constitution, Article 1, Section 23. That's
So
like,
essentially, the factual record is such that Detective Kelly he's doing a search for storage unit businesses.
yeah, Detective Brewer was the one who
Detective Brewer, the detective, all right, doing a search of storage unit businesses in and around Nassau County. Goes to this one storage on Sadler, asks a question, to find out whether or not the defendant was renting a storage unit there, and that information is confirmed. And then he is shown the entry and exit logs for the business, and there's no subpoena of that information.
that's it precisely.
And he gets that information, and you're saying that that's a violation of the Fourth Amendment, reasonable expectation of privacy in that information, and therefore, she needs to suppress. Paraphrasing the argument.
Yes, Your Honor. This would be analogous to going to a business and getting someone's financial records, or perhaps a bank or that sort of thing. And would submit this under U.S. and Florida Constitution without having the warrant or subpoena. And then the fact that then that goes into number 9, that was used as the basis to
For the affidavits.
right.
Okay. So it's legally obtained information that cannot be used in the affidavit.
Correct.
All right. Let me hear a response. And you can provide a rebuttal.
I'm not sure what defense counsel was talking about when they started talking about the right to privacy in the state of Florida. As the court stated, this is a Fourth Amendment issue, and state of Florida follows the Supreme Court, the United States Supreme Court, in interpreting the Fourth Amendment. The state's position is, to begin with, the burden is on the defendant to show that she had an expectation of privacy in the Sadler Road records. And we're really talking about 2 records. One, the verbal identification to Detective Brewer, she rents unit 17 here. And then the other is that identity records that support that. And then the gate access records. And that she also has the burden of proving that such an expectation was objectionably reasonable. And that is, I provided court and defense counsel with the Saintman Edwards, that's spelled SAINTAMEN Edwards v. State of Florida, 274 Southern 3rd, 1222 out of the 3rd District Court of Appeal from 2019, that the burden is on the defendant to establish that. Edwards. That's out the standard of review. And we're dealing with a third party here, and that in order to invoke the protection of the Fourth Amendment, a criminal defendant has to establish standing by demonstrating a legitimate expectation of privacy. And if I can get to it, it cites Carpenter. Let's see. It stands for the proposition that when it is shared with or turned over to a third person or third party, that there is no expectation of no reasonable expectation of privacy. And then the case that in Edwards, they found that he did not have a reasonable expectation of privacy in a flash drive that was left plugged in the work computer. And it cites to another case in here. When was another computer. I can have just 1 minute. It cites other cases that have to do more with computers. And what I noted in these particular cases is that there is some kind of tie-in between the defendant and then sharing that information. This information that was disclosed by storage on Sadler, it wasn't even it wasn't the defendant's property. It was storage on Sadler's records. And it was records on the defendant, but it was their records, not hers. And then on referring the court to the second case I provided, which is State v. Gibson, Gibson, 670 Southern 2nd, 1006, 1996, directing the court and counsel to footnote number 1, that again stands for the proposition that the defendant has the burden of proving standing to challenge a search. And that the court's determination on standing has to be supported by evidence, not merely from counsel's representation of facts not contained in the record. In this particular case, these records belonged to storage on Sadler, and defense counsel made an analogy and said it's like someone's banking records, and banking records are typical. I know just from practice, typically we issue a subpoena to the bank, but there's no notice required to the defendant, and it's not a subpoena to the defendant. The subpoena goes to the person holding the records. In this particular case, storage on Sadler didn't ask for a subpoena. They turned over the information, and the information was then used. The information that the defendant had, the unit number 17 there, was then relied upon for the search warrant going to motion number 9. In defense counsel's motion number 9, they say that the search warrant is unlawful because it was based on the defendant's pre-Miranda statement, which we've already covered that with Pantane. And then the storage unit records, which the state's position is the defendant has failed to establish any standing to contest it, nor does she have any reasonable expectation of privacy in rental records maintained by storage on Sadler, or the gate access log of who is going in and out of the storage unit facility at storage on Sadler.
Any response?
Yes, Your Honor. The Edwards case appears to be dealing with public employees' expectation of privacy in the workplace, a place where the employer had a policy of allowing others to monitor workplace computers. But in response to the Florida Constitution, right to privacy above federal, I'll read in from the Florida Supreme Court case of Von Eif v. as Zicri, I'll spell that, VONEIFF v. AZICRI, 720 Southern 2nd, 510, Florida Supreme Court, 1998. While an implicit right of privacy is recognized under our federal constitution, Floridians enjoy an explicit right of privacy under Article 1, Section 23 of the Florida Constitution, which provides in pertinent part, every natural person has the right to be let alone and free from governmental intrusion into his private life. And enacting this freestanding constitutional provision, the citizens of Florida opted for more protection from governmental intrusion than that afforded under our federal constitution. The state constitutional right to privacy is much broader in scope, embraces more privacy interests, and extends more protection to those interests than its federal counterpart.
You're basing your motion though on a Fourth Amendment violation, correct?
Yes.
Correct.
Uh,
You're basing 8-9 on a reported Fourth Amendment violation, correct?
That's why I was also, as far as my reading of it, or when I was brought in, I'd be basing it on Florida Constitution as well.
Well, the Florida Constitution expressly states that the Florida courts are to interpret the Fourth Amendment to provide no greater protections than that has been interpreted by federal courts and the U.S. Supreme Court. I'm sort of paraphrasing a little bit, but I think I recall that. So I'm not sure that if it's a Fourth Amendment ground, that this court can legally accept an argument that ought to be given, you know, the defendant in this case or any case, greater expectation of privacy or a broader right to privacy than that which has been determined or interpreted in the federal precedent. So I want to kind of make it clear that that's an issue. If you're trying to say I've got to give more protections to Ms. Kessler than she would otherwise receive in federal court.
Well, that's our argument as to the detective obtaining those records pertaining to her business activities.
All right, thank you. All right, counsel, I believe we've covered everything.
Because we still have motion number 10,
Oh, that's right, that's right.
because we had entered into a stipulation regarding the report about the domestic incident at the home of Jolene Cummings and Jason G, which occurred in, looks like May 9th, 2018. And our motion moves to suppress evidence obtained as a result of a warrant for cell site data, because the warrant, the affidavit for the warrant, alludes to this domestic violence incident as something that should be considered in probable cause, that somehow Kimberly Kessler was involved in a homicide or a violent act towards Jolene Cummings, when the Nassau County Sheriff's Office was fully aware, and the detectives in this case were fully aware that this case involved an incident between Jolene Cummings and her boyfriend, Jason G, and that it had nothing to do with Kimberly Kessler, and that to include that in an affidavit for a warrant was misleading, misrepresentative, and basically dishonest. And we believe that because the affidavit contained allegations we think were determined to mislead the court, that the warrant, anything received as a result of that search warrant should be suppressed. And that is just our argument, simply that that material was somewhat misused in the affidavit for the warrant, just to mislead the granting judge or the warrant, the judge to whom the warrant affidavit was submitted, that it was used to mislead that judge, and therefore the warrant was impermissibly granted, and all of the evidence should be suppressed.
Ms. Thurston.
we have
Automatically have access to law in the case unless they're filed.
Yeah.
Not always filed.
I haven't. Oh.
Go ahead, Ms. Thurston.
Thank you. Again, Your Honor, in defendant's motion to suppress number 10, they make additional arguments besides the one just made by defense counsel. So
Let's address one made first.
As to the allegation that there was an intentional misrepresentation, I believe the standard is set out by, I think it's the Franks case, and then the court has to, the burden is on the movement to point out the specific portion of the affidavit alleged to be defective, allege the defect consisted either of a deliberate falsehood or a statement in reckless disregard of the truth, and offer proof supporting the allegations in the form of affidavits or other sworn or reliable statements of witnesses, or satisfactorily explain their absence. In this particular case, and turning now that you have a copy of the application for warrant, the affiant, Detective Kelly, goes through all the evidence, and it does state that on Monday, 5/14/2018, Detective Harrington conducted a follow-up investigation at the residence in Hilliard. Detective Harrington was granted access to the residence by a family member and observed the interior to be in disarray. He observed damage to a bedroom door and kitchen cabinets consistent with kicks and strikes. Based on the interior condition of the residence, it is possibly that a violent struggle occurred at some time. However, there's no evidence of foul play at this time. So the state's position is that is not a false misrepresentation in any way. Detective Harrington said today, defense counsel in their motion refers to Deputy Pinkston's report as an alleged burglary, a violent struggle, domestic violence. But the report was an information only -domestic. That's the report that's made by Deputy Pinkston and attached to defense counsel's motion number 10. And it alleged that according to his report and according to Detective Harrington's testimony today, he had Pinkston come out to the house, and Pinkston said, I think the broken cabinets are from G. The incident with G, but I don't know when or how there was the holes consistent with strikes or kicks made to the master bedroom door. Then further reflecting back, so there is no misrepresentation. The argument would be is that there's an omission, and that the warrant doesn't say, oh, but Pinkston said that the damage to the cabinets had occurred with G, but that is cured because there was, first of all, there's no evidence that it was a willful misrepresentation or a willful omission, nor would that fact change the probable cause in any way. And that's what the court would have to do. If you found it to be a willful omission or a willful misrepresentation of the facts, then you have to determine whether the omitted facts, that being that Pinkston said, the cabinets, that's between G and Jolene Cummings, that would somehow, one, that it was intentional or reckless police conduct to leave it out, and that if it was in, it would have defeated probable cause. And the state's position is there's no way, had that sentence been added in, that it would have defeated the probable cause that's set forth in the warrant. And then as to the other arguments that were made in defense motion number 10, are those being abandoned?
No, they're cascading from the first, from the motion number 2, and they follow from that. And we combine those, but the main argument of number 10 is that there was a willful omission. We allege that. We allege the facts in paragraph 4, and we make the argument, I believe, in paragraph 9, that it was not explained to the judge that this was already determined to be involved with someone who was not Kimberly Kessler. And that is basically the argument in number 10. We believe it was a reckless disregard for the truth as set forth in Frank's. We've alleged that. And we say that without the misleading portion, with the misleading portion of the affidavit excised, the affidavit fails to set forth probable cause. And that also combines with the previous motions and the cascading of the facts.
Like to add in,
Nothing additional based on that.
one thing I am concerned about is, you know, the real information beforehand, but I'm having trouble locating the actual written intent motion. Has that been filed? Yes, it does.
Oh, no, I just wrote on it, but I just saw it.
What date was it filed? Was it filed with the other ones, or?
No, sir, it was filed April 6th of this year.
April 6th. And I think what's happened is that y'all filed these earlier and you refiled them, I guess.
Okay,
You filed
that's-
some amended ones. The 10, I think, was added later.
I got it. Here it is. I got it. I was struggling to find, I mean, I was reading them yesterday and I couldn't find it. Wanted to make sure I had the copy. It's in there. All right. All right, council, I'm gonna take all this under advisement. There's a lot to kind of sort through on this. I appreciate everybody's advocacy and, you know, pointing out the arguments and conceding those things you feel like you can concede and trying to help narrow down the job I have to do on these motions. So I will try to get the order out to you as soon as possible. We do need a pass date for the case, which is scheduled for trial obviously in early December.
Judge, we have a motion for a jury questionnaire, which needs to be heard, I think, sooner than later. And I know this person said she wasn't prepared to hear it today,
Okay.
that I think it's really, I think in the next 2 weeks, because I think
Is it
time,
going to, I didn't mean to cut you off, I thought you were done.
I don't know the time between the time the clerk sends out the summonses, but our request is that this questionnaire go with the summonses.
We would be issuing them 2 weeks before.
Okay.
Jury selection, the summons, but we'll probably do a special summons issuance for this case. Just because it'll be easier when we've got normal trial week, the week after, so we'll probably do a special summons. I gotta get Sue Gottlieb down in the clerk's office to talk about that. Is there gonna be any kind of objection from the state's standpoint, just into the general concept of a questionnaire?
No, sir, we want to come up with some of our own suggestions
Okay,
too.
so we really, what you guys have got to do is get to meet you for, see where you are, and then if we iron out the differences in hearing.
Yeah, I suggested that to Ms. Thurston already, that she could incorporate, we could have a joint questionnaire, so.
I'll be very candid, I don't like questionnaires in most cases, because I think I can get down to the point usually a lot easier when it's in person. I will say in this case, I see the merit in possibly doing a limited questionnaire for purposes of, pretrial publicity and knowledge about the allegations and whether you know any of the folks involved in the case. So I'm not, normally I'm kind of, guys, we just get this done in person, but I would have necessarily a strong objection to, in a general sense, to limiting it to those types of issues so that we can sort through it and get, those are real threshold issues, obviously, that we've got it before we ever get to question one. Finding a panel of individuals that can, that even if they know about this case, can set aside any knowledge and judge this case based on evidence and it's presented at trial. So, So what, on timeline on this, I mean, I can give you, I'll make time, but it seems like y'all really need to sit down and talk, so when do you believe it is appropriate to come back for whatever reason for just a status?
Probably late October, late October.
October 14th.
We can, yeah, that's a, October 14th is a Thursday, right?
Yes, sir.
Okay, yeah, we would do it, yeah, we'd be on Thursday. That's fine, October 14th is, for just a status pretrial. And as far as the defense goes, are you all done with your depositions for the most part?
Yes, sir. We're done with discovery,
Okay.
depositions. I do anticipate there being a few motions in lemonade that we would like to try to get prepared in the next few weeks.
Okay.
So I do flesh out some of those evidentiary issues before trial.
And we're also trying to stipulate to as much as we can, given our clients.
Understood. I understood the limitations there. So that tells me a lot. I mean, you guys have obviously been working pretty hard to get through the discovery and the deposition. So we'll talk about a little bit more on the 14th about where you are on a possible questionnaire and also motions and that may need to be filed. And we'll whatever time you need, we'll make it. Okay, because I really, now that all the discovery is completed, that you know of anyways, nothing else surfaces between now and December, we should be ready to go and start with jury selection. So, yes,
I
you're
just have,
rising a little slowly, though.
Yes, sir.
It concerns me.
yes, sir. It just, I'm sure the court recalls, to say that discovery is all completed and the depositions have been done. Defense counsel opted not to take a lot of depositions, and that caused the court some concern earlier. And I think there was some discussion about whether it should be addressed with Ms. Kessler or not, the defense's decision not to take depositions of a number of witnesses. So I know they say they're done, but it's not because they're all completed, it's they're opting
From a
not to.
trial
do them.
strategy standpoint, it's, you have taken depositions.
Correct.
And the lead detective and
No,
No.
sir, not a here, no detective. But he did write a,
51.
yeah, I was gonna say 60-page report.
the,
Very thorough.
listen, I remember we kind of got a little tense a few hearings ago on this, and as officer of the court, there's trial strategy involved, and I mean, if you are all telling me, we have looked at this from a trial strategy standpoint, we don't want to take any of the depositions, and we've taken the ones we want to take. Then obviously as a court, unless there's evidence to suggest otherwise, I take those statements at face value, and I would be more than happy to go over that with Ms. Kessler. I will say that that probably is not a promising prospect that she would actually respond to my questions, but perhaps there would be a change. You never know. So I'm happy to try to do that at some point, but are you telling me, counsel, that you guys have looked at everything and from a strategy standpoint, you don't want to take any of the depositions and you're taking all you need to take?
Correct. We're ready to proceed to trial.
Okay.
Judge, the only thing I would suggest is, I know the court, Nassau County, usually jurors are summons for Friday, but I would suggest that, I don't know, I just think that if.
Now, those are the old days.
Okay, when
That's
do
the
you,
old days.
when you're,
COVID has forced us, we don't bring them down here until they are assigned to a case.
Okay.
Now, it's all done, over the internet and the clerk's website. We do our jury qualification just over the internet and to through, they answer the same questions, and we review their responses, the judges do. And then we randomly assign them to, whatever trials we have. And so they don't have to come out here on Friday and whatever. We do select juries, the actual selection process on a Friday, just because it's easier. But in this case, we have flexibility. We can do it. We can set up a schedule for whenever. okay?
I'll so voir dire then in this case will be like Monday and Tuesday. I think it's gonna take more than one day, is what I'm saying.
We can do it then. We can start on Friday, keep on going Monday, Tuesday, whatever. I mean, we can start on Monday, that's fine. I have flexibility to do that, okay? So I think we could talk a little bit more. I mean, right now, it's set for the week, starting Monday, December, whatever that,
6.
whatever that first week is. And I'm
sorry, Your Honor, I thought you had reserved the week of the 29th for jury selection. The week of the 29th for jury selection, and then the week of the 6th for the trial.
Yeah, it is that, we did do that. So, but we have flexibility. If you wanted to start sometime that week or whatever, Wednesday or Tuesday or whatever, we can talk about it, and I can listen to what your scheduling suggestions are, and we can certainly do that, okay? So is there something I need to, the defense standpoint from scheduling?
No, I was thinking that earlier for jury selection, the better. For some reason, I didn't understand that it was the 29th. I had the 6th.
Well, I've forgotten too, Miss Thurston is,
I had the 6th and the 13th,
Clearly.
so I'm wrong then.
yeah, well, and again, we can do it. You know, I felt like that it would take several days, obviously, for jury selection. With a questionnaire, I still think it'll take several days. I don't know necessarily that the jurors will need to all be down here at that time. Particularly if they filled out, or, if they fill out questionnaires and then go home, you guys can read them, you can look at them and see where it takes us. There's a lot of different ways that we can do it. I think the first thing is for you guys to get the questionnaire together, and then I'll kind of inform me on kind of how I want to go forward with all that. Okay? But you guys, I've forgotten about the 29th, but yeah, you've got plenty of time to do it. It doesn't have to be done on a Friday, and certainly doesn't have to be done in one day. All right? It would be nice, but I'm not optimistic on that, given all the issues. So we'll talk about the 14th. Will you all meet and confer about your questionnaire before the 14th? Is we all do that?
Yes, I've sent it to Ms.
Okay.
Thurston and asked for her input, so.
All right, so then we'll just have you guys meet and confer further on that. And we'll start talking about, we do need, I've got to get with, like I said, the clerk's office and start figuring out how we're gonna do summons and how many summons we're gonna need, that type of thing. All right.
So just so you know, why I was asking about earlier being better, the week of December 13th, 14th, and 15th, I have a 3-day hearing scheduled in Duval County, so I was hoping that we could back up jury selection, but now that we know we're scheduled for November 29th, that makes it easier.
You're good.
I'm good, okay.
Well, okay.
If not, Mr.
No, we're not, you've been involved in the case for, you're gonna be there. We'll work around, but I would ask you to work around our schedule too.
Well, no, the 29th and the 6th is perfect.
All right,
I think we should be able, 2 weeks should be enough.
okay.
I just had the wrong 2 weeks, so apologize.
That's all right. It's okay. All right, well, with that, unless there's anything else, everybody, and we'll see you on the 14th, and thank you, and we'll be in recess. All right. Thank you.
Thank you, Judge.
Thank you. I'm gonna turn off, I'm gonna end the Zoom session now.